Good afternoon, everyone. My name is Giacomo Delledonne. I'm an assistant professor of constitutional law at Scuola Superiore Sant'Anna in Pisa. I'm one of the editors of the STALS research project and paper archive, together with Professor Giuseppe Martinico and Filippo Fontanelli. Today, I'm very glad to introduce another STALS seminar, a book launch, which will be devoted to a recent insightful monograph whose title is EU Values Before the Court of Justice, Foundations, Potential Risks. This book was published earlier this year within the Oxford Studies in European Law. We are very happy to discuss the book with its author, Dr. Luke Dimitrios Spieker. Thank you, Luke, for being here. And we have two discussants who will provide make some points about the arguments raised in this book. They are Anna Bobić, currently serving as a referendaire at the Court of Justice of the European Union in the cabinet of Advocate General Tamara Chapeta, and Professor Pál Sonnevend from the ELTE Laurent University in Budapest. Thank you for accepting our invitation to taking part in this book discussion. There will be some time after Luke's first intervention and the discussant's intervention for a Q&A session. This webinar is part of the events organized in the framework of the Enacting Jean Monnet module. Enacting stands for European Values in Context, Challenges and Comparative Insights. Therefore, this book is very topical, very relevant, and it's a great reading for all those interested in this specific area of European constitutional law. So I think we can start. So our tradition, is to start by an intervention from the author. So Luke, thank you for being here, and the floor is yours.
Yeah, welcome also from my side. Thank you very much for inviting me to present my new book, EU Values Before the Court of Justice, in this forum. And special thanks also to Pál and Anna for agreeing to discuss it with me later on. In the following 25 minutes, I will start by briefly sketching the context in which the book was written and outline my main research objectives. And after this introduction, I will guide you through the structure of the book and summarize some of its central theses. As you will see, the book has a rather panoramic structure. It touches upon many different fields of EU law, and as such, we cannot delve into all topics with the same depth. But if something sparks your interest, please do not hesitate to raise these points in the following discussion. So let us begin with a brief introduction to the central object under investigation. Since Lisbon, the values of democracy, the rule of law, and human rights have been enshrined in Article 2. The Union is founded on these values, and they are also common to the member states. For a long time, however, this provision was a kind of blank spot on the map of European Union law. It played practically no role in the case law of the Court of Justice. This has fundamentally changed during the past 5 years, and I guess most of you will be familiar with the story. Since 2012, an increasing illiberal trend can be observed in several EU member states. Governments in Hungary and Poland, but also to a lesser extent in other member states such as Romania, Bulgaria, or Malta, seek to eliminate checks and balances of the political process. Due to the lacking or insufficient responses by other EU institutions, such as the Council, the Court of Justice stepped in and became the central forum to address and remedy such developments. Since 2018, the Court started activating the values in Article 2 and assessed the member states' legal systems against these standards. And this is also the point when I started writing my book. In February 2018, I was an LLM student in London and participated at a conference on the rule of law. One of the speakers was Thomas von Danwitz, the German judge at the Court of Justice. He pointed us to a judgment rendered one day before, which he considered to be quite important for countering the rule of law backsliding in Poland. The ruling he referred to was the Portuguese judge's case. And when I looked it up, I immediately knew that this was something big, a very important moment in EU law. And based on this intuition, I started researching around this issue. And the longer I worked on it, the more judgments were produced that mentioned Article 2. By the end of 2022, when I corrected the proofs of this book, the court had referred to Article 2 in over 100 judgments. So since 2018, a new value-based line of jurisprudence has developed that now goes far beyond the rule of law crisis. Against this backdrop, my book pursues three central objectives. Looking back, I trace and systematize the court's case law and anchor it in EU legal doctrine. In a second step, the book provides a conceptual framework for the further development of the court's jurisprudence and explores its potential trajectories. And the book concludes, third, with a critical reflection of the activated Article 2 and develops possible strategies for recalibrating the case law. So let's dive into the individual parts. The book starts by outlining the first 5 years of value-based case law. And as I said before, the critical breakthrough seems to have occurred with the Portuguese judge's case, to which we also will return in a minute. In the central paragraph of this judgment, the court stated that Article 19, which obliges member states to provide effective judicial protection in the fields covered by EU law, gives concrete expression to the value of the rule of law. And in my view, this is a historical move. The court activates Article 2 by operationalizing it through more specific treaty provisions and starts assessing the member states' legal systems against these yardsticks. This case law was quickly consolidated, as you can see, and the cases keep coming. Despite these developments, many remain skeptical about the judicial applicability of Article 2. And this is where the second chapter of my book comes in. When it comes to invoking Article 2 before the court, three main objections are commonly raised. First, some argue that Article 2 contains moral values, not legal obligations. This objection was, for instance, raised by the Polish Constitutional Tribunal in its judgment of 7 October 2021. But it is also very prevalent among German academics. Second, it is suggested that the court lacks jurisdiction to review compliance with these standards. And third, it is usually argued that the values in Article 2, democracy, the rule of law, and human rights, are too indeterminate to be justiciable. They are not precise and unconditional obligations that can be enforced before the courts. In my view, these objections are hardly convincing. So let's start with the first one. This argument departs from the wording of Article 2, which specifically states the Union is founded on values. This seems to evoke that Article 2 is not an operative legal provision. Especially in legal theory, values are usually distinguished from rules and principles. Values tell us what is good or bad, rules and principles what is legal or illegal. There are, however, several arguments against such a reading. To start with, relying on the wording is a weak argument in EU law and probably not the best starting point. In fact, the terminology of the treaties is often misleading and inconsistent, and this is the result of its multilingual drafting process, which is prone to such inconsistencies. Also, historically, there are strong arguments for the legal character of Article 2 values. Already before the Lisbon Treaty, Article 60 EU Amsterdam listed the Union's founding principles: democracy, the rule of law, and fundamental rights. With the Lisbon Treaty, this wording was changed and the principles became values. The travaux préparatoires to the European Convention, however, which introduced the notion of values in Article 2, clearly indicates that the drafters did not intend to weaken the provision's legal force. To the contrary, and to just give you one example, Valéry Giscard d'Estaing, the president of the European Convention, clearly stressed that the values in Article 2 should be définis juridiquement de façon suffisamment solide. So the values in Article 2 should be values that are defined in a legally solid way. So they should be legal values, not moral values. They should be of legal character, not of, as he said here, de caractère plus émotif que juridique. The Court of Justice has confirmed this interpretation. It emphasized in its rule of law conditionality judgments that Article 2 is not merely a statement of policy guidelines or intentions, but contains legally binding obligations for the member states. The second objection suggests that Article 2 can only be enforced by the Council through the Article 7 procedure. To me, this argument is also unconvincing. Once we establish that Article 2 contains legal principles, it becomes part of the court's jurisdiction under Article 19. Some note that Article 7 features very high procedural and substantive thresholds, which should not be circumvented by the Court of Justice. However, political and judicial procedures have very different consequences, which in my view justify different and diverging thresholds. Article 7 is a political procedure that may lead to the suspension of member state rights. I mean, this is a very severe sanction. The court, however, operates in judicial proceedings that may only lead to penalties, namely under Article 260 TFEU. The third and final objection is more problematic. The Union's values, democracy, the rule of law, and human rights are extremely open and indeterminate. Abstractly, there are two avenues through which Article 2 could be made justiciable. First, one can apply Article 2 in combination with more specific treaty provisions that operationalize and translate these values into concrete legal obligations. And second, one could treat Article 2 as a freestanding provision. So far, the court has chosen the first option. As we already saw with the Portuguese judge's case, it started operationalizing the values in Article 2 through other treaty provisions, primarily Article 19, that give concrete expression to the value at issue. In principle, this reasoning can be applied to all treaty provisions that give specific expression to the values in Article 2. In the case of Junqueras Fis, for instance, which concerned the immunity of a Catalan MEP, the court indicated that Article 10 concretizes the value of democracy. And in its ruling on the rule of law conditionality regulation, the court provided a vast array of possible connections between Article 2 and other treaty provisions, including several charter rights, which define the scope of the values of human dignity, freedom, equality, and respect for human rights. So the operationalization of EU values has become a consolidated case law. The question of whether Article 2 can be invoked as a self-standing provision, however, remains controversial. And the pending infringement procedure against Hungary for violations of LGBTIQ rights could become a test case in this respect. Here, the Commission explicitly mentions Article 2 alongside a number of other provisions as a self-standing moyen. And it remains to be seen whether the Court of Justice will follow this approach, but we can also discuss that later on. I treat exactly that question in my book. In the third chapter, I then tried to develop a new, deeper understanding of Article 2. Let's take a step back. Article 2 is a provision whose scope of application covers not only the Union legal order, but also the entire legal orders of the member states. Unlike the Charter, it has an unrestricted scope of application, and this means no part of the member states' legal orders is exempt from the obligations in Article 2. In this sense, Article 2 applies in two dimensions. First, in a EU dimension, which covers the entirety of the EU and the members, which covers the EU legal order. And second, a broader dimension, which covers the entirety of the EU and the member states' legal orders. And this broader dimension can be best described by using the German concept of Verbund. This concept expresses the idea that the EU's and the member states' legal systems form a mutually complementing whole. So why did I opt for this rather bulky concept of Verbund? On the one hand, the notion of Verbund is an open, neutral concept. It is an analytical tool that allows us to grasp the entirety of the EU's and the member states' legal orders. And this distinguishes it from concepts such as union or federation that aim at reconstructing this common whole as a legal, institutional, or political entity. So what we have here is simply an analytical tool. On the other hand, the concept expresses the complementarity of the national and EU legal orders. Some might ask why I'm not simply distinguishing between an EU and a member state dimension. Well, in my view, this would not be as precise. First, distinguishing between an EU and a member state dimension will hardly provide clear-cut results. EU law relies on the member states' institutions, their governments, parliaments, courts, and administrations. These institutions are, to a large extent, integrated into the creation, application, and enforcement of EU law. If the member states act in this capacity, are they then addressed by Article 2 as member states, or rather as agents of the EU? This problem can be overcome if we use the Verbund dimension. Second, such a separation would neglect the role of Article 2 as a constitutional basis for the common whole of the EU and its member states. As we will see later on, the EU level can also receive impulses from the national one when it comes to fleshing out the values in Article 2. This idea would be lost if we would distinguish only between an EU and a member state dimension. So, even if Article 2 applies in these two dimensions, EU and Verbund, this does not mean that it applies the same way. In fact, its inner structure suggests that Article 2 fulfills a different function in each of these dimensions. In its first sentence, it states that the Union is founded on these values. And the second sentence merely states that these values are common to the member states. Based on this wording, the two dimensions of Article 2 seem to express different constitutional rationales. To better grasp this distinction, we might resort to well-established concepts of constitutional theory. One central dichotomy I employ is the one developed by two German constitutional judges, Ernst Wolfgang Böckenförde and Konrad Hesse. Konrad Hesse perceived the Constitution as a Grundordnung, a basic order which contains steering guidelines for the organization of the entire legal system and which radiates into it. Ernst Wolfgang Böckenförde, by contrast, understood the Constitution as a Rahmenordnung, meaning as a lean framework for the political process, which rather contains negative limitations than positive guidelines. And this distinction is so rudimental that one will find the respective expression in practically every European legal order. Some may call it negative or positive constitutionalism. Others, like in Italy, Giorgio Pino, call it Costituzione come limite or Costituzione come fondamento. I personally like the distinction between thin and thick forms of constitutionalism. So I argue that the two dimensions of Article 2 each tend towards one of these constitutional rationales. In its EU dimension, Article 2 gives expression to a thicker form of constitutionalism. In its Verbund dimension, it is reduced to a much thinner, primarily restraining form. It is rather about limiting than steering. Based on this, it becomes clear that Article 2 features a dual character. It is a constitutional core of the EU legal order and a constitutional frame of the Verbund. What does all this mean in legal practice? It follows from these considerations that Article 2, depending on the context in which it is applied, has a different function. The thick constitutional underpinning of Article 2 in its EU dimension can justify a prevalent role in EU constitutional law, for instance, as a focal point for the interpretation of primary law. By contrast, a thinner constitutional rationale in the Verbund must lead to a much more restrained function. And as such, the dual character of Article 2 requires a different judicial treatment in each dimension. Based on this distinction, I then explore the potential of Article 2 in each of these two dimensions. Starting with the EU dimension, I demonstrate how Article 2 can strengthen the EU's own commitment to its values. The EU is often criticized in this respect. Flagrant human rights violations at the borders, democratic deficits in the last financial crisis, demanding standing requirements or limited judicial protection before EU courts, the list is long. I argue that the Court of Justice can respond to such issues by interpreting primary law in conformity with Article 2. In particular, the Court could use Article 2 to develop substantive hierarchies in EU primary law. Let's again take a small step back. Despite the failure of the Constitutional Treaty of 2005, the content of the treaties is widely understood as being the Union's constitution. However, it is complex and confusing. It currently features over 500 articles and 32 protocols. All of these provisions are formally of equal rank. Some speak of a constitutional chaos or an over-constitutionalization of EU law, meaning there is simply too much constitutional law at the EU level. Too much constitutional law can lead to problems. It weakens a central function of constitutions. By elevating certain areas to the rank of constitutional law, we characterize them as special. In particular, they take precedence over ordinary law and guidance interpretation and application. The more legal interests acquire constitutional status, the weaker this guiding function becomes, and the more the individual constitutional interests compete, and the more trade-offs we need to strike. In union law, this problem takes on extreme features. Primary law goes far beyond what we would consider as elements of genuinely constitutional content. It regulates in much detail many policy areas. As such, trade-offs frequently occur. This is evidenced by the struggles in EU migration law or in issues of economic policy, such as austerity measures, where fundamental rights, effective legal protection, or democracy are just one of many elements in a complex balancing process. An understanding of Article 2 as the Union's constitutional core can help overcome these deficits. I propose deriving the constitutional law of the EU from the values in Article 2. Only those treaty provisions that give specific expression to a value enshrined in Article 2 have a genuine constitutional content. This would include, for instance, the Charter of Fundamental Rights, provisions on the Parliament and Council, European elections, legislative procedures, or judicial protection, as well as the Union's competences. This would allow the Court to introduce substantive hierarchies between those treaty provisions that give expression to an Article 2 value and those that do not. This could lead to a threefold hierarchical division of primary law. Article 2 at its summit, the EU's constitutional core. Provisions giving expression to an EU value would be allocated at a second level. They would form the Union's substantive constitution. And the rest of EU primary law would form a third level. This would include the Union's policy areas, its economic and competition law, migration, trade, or agriculture. What follows from all this? First, as already mentioned, constitutions take precedence over other law. This means that third-level treaty provisions must be interpreted in accordance with Article 2 and the EU Constitution at the second level. Second, this system can lead to a layered system of protection. The constitutional core enjoys the strongest protection. It might even be considered an eternity clause and thus be withdrawn from treaty amendments. The third level would enjoy the least protection. One could even go so far as to deconstitutionalize these provisions. In such a scenario, the Court would, where possible, defer to the EU legislator in the respective field. In particular, it could stop using the third level of primary law as a yardstick for the judicial review of EU legislation. Instead, the Court would reduce its judicial review to provisions with genuinely constitutional content, namely those at the second level. Let's come to the Verbund dimension. Here, Article 2 corresponds to a mere constitutional frame. Its function here is rather guaranteeing a minimum of constitutional homogeneity. Like any federal system, the European Union presupposes a certain degree of homogeneity among the constitutional systems of the member states, although the required degree of homogeneity is of course lower than in federal states. In my view, Article 2 guarantees the constitutional homogeneity across the Verbund, not only in one direction, so from top to bottom, but multidirectionally, meaning also horizontally between the member states and from the member states towards the Union. As such, Article 2 creates a system of mutual stabilization. In my book, I outline these three avenues, top-down, horizontal, and bottom-up, and demonstrate how the courts can contribute in each avenue to stabilizing the constitutional homogeneity in the Verbund. Starting with the top-down avenue, I analyze how the court can, and in fact already does, review value compliance in the member states. After sketching the main case law on the Polish judiciary, I explore how the court can expand its case law to the value of democracy and the essence of fundamental rights to also protect them against violations in the member states beyond the scope of other EU law. One recent example demonstrates how far we have already come in this respect. When the former Polish government introduced the so-called Lex Tusk, a committee investigating Russian influence on internal affairs which targeted only one person, namely the Polish opposition leader, the Commission did not hesitate to initiate an infringement procedure. This procedure was based on the principle of democracy enshrined in Article 2 and 10, something I also suggest in my book. Horizontally, there are basically two avenues for reviewing the value compliance of member states, both directly before the Court of Justice through Article 259 TFEU, and indirectly before national courts through so-called mutual recognition regimes such as the European arrest warrant. And finally, I explore how constitutional courts can assert in tandem with the Court of Justice the Union's own value compliance. Currently, such a bottom-up review takes especially place within the framework of constitutional identity claims. Such constitutional identity reviews are extremely conflictual. One only needs to have a look at the reactions following the German Constitutional Court's PSPP judgment, which, even though an ultra-virus review, seeks to protect the principle of democracy, which is part of the German constitutional identity. I suggest articulating such claims under the banner of Article 2. In fact, the values of Article 2 are structurally linked to the common constitutional traditions of the member states. They provide the main sources to flesh out the content of Article 2. The member states' constitutional traditions will usually correspond to those principles that form their constitutional identities. And as such, the member states' constitutional identities provide a central point of reference for establishing the content of Article 2 values. Against this backdrop, I suggest that national constitutional courts should articulate concerns regarding the compatibility of union law with these fundamental principles, not via the concept of national identity or via identity reviews, but via the common values in Article 2. And this might help turn heated identity conflicts into a more constructive dialogue that stabilizes the constitutional homogeneity in the Verbund. Well, this brings me then to the last part, which I will treat only very briefly in view of the time available. Of course, the activation of Article 2 by the Court of Justice does not come without risks. This applies especially to the enforcement of values in the member states. Well, the usual suspects, the Polish and Hungarian government, voice always the same objections. The values are too indeterminate and jeopardize the rule of law. The respective government has been democratically elected, including its agenda disregarding EU standards. And finally, the classic, the federal balance, competences, identity, and pluralism are at risk. These considerations hark back to a greater legal mind, namely Carl Schmitt, who coined the term of a tyranny of values in the early days of the German Constitutional Court. Still, these concerns are legitimate. If the Luxembourg judges start fleshing out extremely indeterminate values such as democracy and the rule of law and start assessing the member states' legal systems against these yardsticks, that might jeopardize exactly these values. Against this backdrop, it seems clear that the court must use the values in Article 2 with utmost restraint, especially in the Verbund dimension. And this has also been stressed by judges at the court itself. Here, to quote just Dean Spielmann, Article 2 TEU has the potential to become an ultra-powerful tool. There is a great temptation to use the concept exponentially. So, to maintain the union's federal balance, I outlined several judicial techniques and strategies how to implement such a restraint. But again, maybe we can speak about this in the following discussion. And with this, I would like to end and provide you with, well, 4 key takeaways that maybe summarize the central thrust of my book. First, I would like you to take away that it was with the Portuguese judges case and the upcoming case law that Article 2 has become justiciable before the Court of Justice. Second, Article 2 features a dual character, oscillating between an EU and a Verbund dimension. In its EU dimension, Article 2 constitutes a constitutional core that stands at the summit of the EU legal order. In its Verbund dimension, by contrast, Article 2 is a constitutional frame that seeks to guarantee a basic level of homogeneity in multiple directions, top-down, horizontal, and bottom-up. And with this, I would very much like to very much thank you for your attention.
Thanks indeed for this fascinating presentation. As you rightly imply in the introductory chapter of your book, there is much literature on these topics, but the focus of your research is both narrower, in that you focus on the court, and broader, in that you move beyond the rule of law talk, etc. So now it's for our first discussion to make comments and raise questions. Bobić, please.
Thank you. Thank you. Thank you, everyone. First of all, thanks a lot to Giacomo and Giuseppe for having me here, and well, Dimitri, thank you so much for having me. I'm so happy to comment on this book. You know, before this event, I got to read parts here, parts there when you need something for something, but this time I got to read it cover by cover like a novel, which doesn't imply that it's fiction, but it was really great fun. So thank you. Before a short, brief disclaimer that given that I work at the Court of Justice, nothing that I say is, of course, an official position of the court, but when you hear what I have to say, it will be clear to you that the court would never agree with that. All right, so I will structure my comments in 3 groups: praise, critique, and food for thought. So let's start with the praise. Yeah, so this is a great book, really great, very thoroughly researched, well written. We should all use illustrations. Lawyers should not be shy of illustrations. They are so helpful. They really frame your points and bring them home. And we should all write, as you look, right, Dimitri. Sorry, I keep calling you Luke, and I know that I keep calling you Dimitri in other occasions. So we should all write through critique. So what do I mean by this? So, you know, as you read this book, Dimitri constantly gives you the critique first. So he says, here's the critique, and then frames his arguments in response. And being a commentator here, it was a bit difficult to find something that surely he hasn't thought of, the critique that hasn't actually crossed his mind, but I'll try. So overall, this is really a book that is a great fun to read. What I really also appreciated is the use of sources from multiple countries, multiple languages, as you also emphasize in the introduction. We should not just focus on Germans. The German literature on EU law, or the English language literature on EU law. So in that respect, well done. And I think that the last biggest compliment to your book is that it really seems like the Commission is thoroughly reading it and following it and implementing it in its infringement actions. So we have a pending case based on Article 2 alone, and then afterwards we have another infringement based on Article 10, I think, against Lex Tusk, right? So they are following in your footsteps. All right. And to move more specifically to another area of your book that I really, really loved is the substantive hierarchy of the EU's constitution. So this framing of the treaties is, I think, something that we need, and something that would really bring coherence to EU law. And so you start by saying that not all is well at the Court of Justice. And you show that the values in Article 2, in fact, act in a way as a constituent power. So in the EU, it's not we the people, it's we the values. And this can be very, I mean, this is very convincingly shown. Although I must say that I think that you selectively pick when the text is good enough and when the text is not so relevant. As you said yourself, that the text can easily be broken. But I find the three levels very convincing. So we have the core, the can of Article 2, and then we have the provisions which give expression to Article 2. And I mean, you say in the book, you know, this is not yet fully operationalized. I would really love to actually see a paper or something that gives us a proper layout of the second dimension. And then we have the rest. I think that what I would be careful about here is when you talk about, for example, conflicts between the second and the third layer, and the rebalancing that the court should be using. You know, you of course deal with the critique that the court is a political player, but balancing between market freedoms and fundamental rights, for example, always also involves policy choices. And I think that this is something that is perhaps overlooked a bit. You know, you say, well, we have fundamental rights in category 2, and we have fundamental freedoms in category 3. And if we acknowledge this difference, you are very right to say, finally, fundamental freedoms will stop being as important as they have been in EU law. But of course, this is, it's a choice which right you balance it against. And I will use the example of the resolution of Banco Popular in Spain, where a bank was resolved, and then this means that a bank was kind of, it was falling apart, and the Single Resolution Board, an EU agency, decided to sell it to another bank. But it was a policy choice how to deal with property rights. Which shares, what are we going to do with which shares, shareholders, deposit holders? And these all pertain to property rights under the Charter. So there are nuances, even within the categories, that we should be mindful of. And something that your categorization really reminded me of, and this is not to say it should have been in the book, you know, whenever you comment on a book, it's always how would I have written it? But it really reminded me of the UK's constitutional statutes doctrine, the differentiation between treaty levels. You know, in the UK in 2002, the Queen's Bench division in Thoburn decided that some statutes are more important than others and have a constitutional status, and therefore can only be expressly repealed. And this is, I think, a very nice parallel to your structure. I think that one should be careful about is treating the court and the treaty text in a chicken or egg situation. So as I already said, sometimes it's the treaty, sometimes it's the court that normatively justifies your arguments, and to really be honest about how far the court can go before the text of the treaty is broken, is perhaps a concern. And then I was wondering whether it's a deliberate omission completely to refrain from defining any of the Article 2 values, to really say, all right, court, that's something that you should do. And as the last point in my praise section, I want to really praise the Verbund as an analytical tool. I think it's super useful. I really like it. I think it's a very flexible tool, and it really moves us away from the triggering federalism discussion. I think it's really useful. But the praise of the Verbund leads me to the critique. I also think that you don't. So my main critique to the arguments made in the book is the bottom-up section of the how you treat the Verbund. I think that you need to be honest about what you mean by it. So you say that Verbund is extremely loose. There is a minimum of homogeneity. We have a very thin idea of constitutionalism there. But the way you use it in the end seems to actually really speak of the homogeneity most. I think that you don't give sufficient space to diversity, and I don't want to go into the value pluralism. I don't want to fall into the Orban critique of different values. I think that Article 2 does contain a minimum for the member states. I do think that the rule of law does contain a certain shared minimum, and I don't think that if the Court of Justice says what the rule of law is, all of a sudden we will lose national diversity. But I think that you don't acknowledge enough the diversity that actually exists. And here, I think this has to do, of course, because everything that is going on, the Portuguese judge's judgment is a response to the rule of law crisis, right? And this is, in a way, it's lucky that the process is triggered, but it also limits us in what we see is going on, I think. So, for example, you talk a lot about constitutional courts of member states, and they, of course, have different ideas how to do things, how to interpret their values. But, for example, you completely omit member states that don't have constitutional courts at all, that don't think in this logic at all. I'm talking about Scandinavia, where judicial review is completely decentralized, and there is not this unifying judicial force. And in those countries, of course, judicial review is not at all something that they see as central. So for them, it's not about, that they would question the rule of law as such, but they would most certainly see it in completely different ways. And so for me, the main critique would kind of be to push constitutional courts or national courts to use Article 2, but also to use the Court of Justice as the forum for expressing their constitutional specificities. If you think perhaps identity is a too triggering term because it has been abused, and I'm also happy that Julian Scholtes is here because I hope he will intervene as well. So what I want to say about this, and I will go through your arguments and offer my thoughts. So first, you offer a substantive argument why national courts should go to the Court of Justice, because Article 2 provides a stronger protection for the principles that come under its scope than Article 4.2, national identity. That's a substantive argument. But what I don't see is why national courts would need EU law at all if they have their national constitutions. Why would they need to use EU law and accept the jurisdiction of the court? Because keep in mind that once a case comes to the court, the referring court is no longer the interlocutor at all to the Court of Justice. It's primarily the Commission who is talking to the court. So in a way, I don't see the incentive for national courts to move away from their national constitutions. Your second argument is that that using the Court of Justice, it allows national courts to consolidate their institutional position in the EU judicial space. So it's an institutional argument of giving them a voice, because you argue that there's an importance to acknowledging the position of the first voice, not the last say, but the first say. But I would say that a direct voice, and you are loudest when you speak by yourself, when you're alone, right? When you're not, because national courts, of course, are always in a gamble. When they submit a reference, they lose power afterwards to do anything. And then you put forward the argument of abuse, right? From abuse. If we use EU law, it prevents abuses of these doctrines by captured constitutional courts in Poland or Hungary. This argument, I think Julian defends very well, and you also refer to him, is that it's a flawed starting point. Every procedure that we have in EU law can be abused, and I don't think that that's a reason why we shouldn't have national constitutional review. And finally, national courts might find a more responsive counterpart in Luxembourg, which is an argument from dialogue. And I think that this kind of sums up my main feeling of unease with the argument, is because I find it counterintuitive that identity claims, which are necessarily divergent, they are supposed to account for diversity of member states' constitutional organizations, should be streamlined to Luxembourg. And I think that, you know, even Maduro in Micaniki, I think was the opinion, said, well, still it's for the national courts to interpret and define this, and we have a common limit to what can be done. So here is where I have some reservations, perhaps, that we don't, you know, reading this section, it seems to me that we don't trust national courts enough because we're responding to the rule of law crisis. So perhaps we could acknowledge the non-problematic divergence a bit more. And that ends my critique part. And now the last food for thought part was kind of the ideas that are not touched upon in the book that maybe you want to consider, or maybe you have some thoughts on that we can discuss. And this is, first, I think that in the book you employ a very specific idea of constitutionalism that is, I'm not going to call it very German, but maybe it's a very founding member states focused. So we have, you know, it's also the talk of the constituent power, which you discard at a certain point, but we speak of a constitutional court, that the Court of Justice is a constitutional court. And this, of course, you know, which one of us has not been at a conference where President Leonard's called the Court of Justice a constitutional court? And if you repeat it enough times, we might all start believing it. But really, to think of the fact that we would have a constitutional court, it means that we have a specific constitutional polity. We have made specific constitutional choices. So maybe some reflection on that. And even when we speak of over-constitutionalization, we start from the idea that a centralized constitutional court, when it touches something, it constitutionalizes it. The second point is enlargement. So all the ideas, I was wondering how they fit with, first, the you know, literature critical of the enlargement procedure itself, so that the accession procedure doesn't do enough. It is superficial in actually bringing the new members on at the same level, and especially in the context of grand ideas for enlargement with the Western Balkans, with Ukraine. Where does this fit? Is it manageable? Do we have a capacity for such an enlargement? And last point is my big worry about infringement proceedings against court decisions and national court decisions. So I agree with you. You know, the Commission has a lot to do, and usually it's not against national courts, and that's all fine and well. And I don't dispute that. You know, Article 2 is not limited to the scope of union law, but I have a great worry with how easily arguments were made in the literature that the Commission should have gone against the German Constitutional Court, for example, because, you know, when the Commission starts an infringement proceedings, the defendant, in a way, is the government of the member state, and when we have an infringement decision, it's basically the Court of Justice telling the government to tell their national courts what to do. So I'm very nervous about the idea that a government should tell a court what to do. And I will stop here. Thank you so much again. I hope you all read the books. Oh, last thing that I forgot to mention, and it's great, actually. It's very short. And this is the flag of the Netherlands Antilles. Justice for the Netherlands Antilles. It was very funny. The poor Protocol 31 was touted as the most insignificant provisions of the treaties. No, I'm kidding. But yeah, thank you. Thank you very much.
Thank you, Anna, for this brilliant intervention, for your comments. Now it's for Pál Sonnevend. You have the floor.
Thank you. I thank Giacomo and Giuseppe for the opportunity to participate. I thank Anna for this really brilliant comment, and most importantly, I thank Luke for writing and publishing this book. I believe that this is how the scholarship of European Union law should be produced and exercised. This book is at the same time positivistic, doctrinal, and theoretical. It has a specific direction, it has a telos, yet it's very solidly rooted in the case law and in academia. So it has everything one should have, not only limited to positivism, not only invested in the idea of developing grand theories, maybe irrespective of what the law is, rather finding the proper balance. So that's something one could show to any young colleague starting to deal with the European law, how you should do this. So as regards methodology, I can only, in any other respect, I can only praise this book. Also, I would express my really extremely positive feelings for the fact that the author basically speaks not only many languages, but also many, to use the word of my dear friend and colleague András Jakob, many constitutional languages. And so the book speaks the language of EU constitutionalism or EU law in broader terms, but also the language of national constitutional law, because they are not the same, and the author reflects on that. And it's very unique that an author can integrate these two perspectives and two ways of thinking, and can deliver a powerful and comprehensive argument. So I can join Anna in saying that it's a real pleasure reading this book, and unlike many other books I had to or I wanted to read, I never felt tired. I never felt the need to have a coffee or get some sleep. It's quite unusual, I would say, at least in my experience. So it's a pleasure. Now, I would comment on four specific subjects that are dealt with in the book, bearing in mind that Luke is probably in a much better position to talk about the content of the book, and I should not repeat what's written in here. First, justiciability, which is basically in chapter 2 of the book. It's a very compelling narrative, how Luke is introducing the binding force, normativity, and justiciable nature of this provision, Article 2, and the values enshrined in it. Yet I was thinking a little bit about the strong emphasis or the strong focus on direct effect, and linking the question of justiciability with direct effect, which, in my understanding, on the one hand, limits the scope or the concept of justiciability. This is reflected actually in the text, but I would still argue that there are many ways EU law can be binding and normative, and direct effect is only one of them. Just think about the distinction that is made, maybe artificially, but in fact it is made, in relation to WTO law. And if you think about the case against Hungary about Lex CEU, the law on universities that basically expelled the Central European University from Hungary. In that case, the court is making a rather interesting distinction between enforcing WTO law against member states in the course of an infringement procedure, but not granting direct effect to WTO law and not allowing the enforcement of WTO law against the European Union itself. So it seems that there are many situations when an EU law provision is perfectly justiciable, perfectly normative and enforceable, still we're not talking about direct effect. So conceptually, that's something one might consider. The second remark on justiciability, and I think that's a fundamental issue at all as regards courts and or the Court of Justice and Article 2. I agree with Luke that Article 2 really delivers sufficiently clear obligations on member states to be enforced by a court. Yet the question is, how much is that and how sweeping is that? And my suggestion is that Article 2, in the hands of the court, can never become a response to a systemic deficiency. This is because of Article 7, which clearly precludes a systemic judgment on the whole legal system by a court of justice. And this is also the very nature of applying the rule of law or democracy or human dignity by a court. If you look into the case law of constitutional courts, the examination is always punctual. It's always very specific issues, narrowly defined in relation to a specific law or a specific provision, as normally constitutional adjudication should be. And I don't think that would change if Article 2 is applied by the court itself, by the Court of Justice, because there must be, using the words US Constitution, a specific case of controversy, there must be a specific problem that is replied to. And so systemic problems basically escape the powers of the Court of Justice, which is not an argument against applying Article 2 by the Court of Justice. It's just a reference to the very limits of Article 2 in the hands of the Court of Justice. Second sort of group of remarks or remark relating to Article 8, and that is when we apply the values vis-à-vis member states. And I skipped part 2 of the book because it was very nicely discussed by Anna. I can only call that part 2 revolutionary, and I might come back to one aspect of that a little later. But going to part 3 and chapter 8 on how we define what exactly is in Article 2, I applaud the author for not trying to engage in an exercise of defining the content of Article 2 and spending chapters on what is rule of law and what is not rule of law. I think it's a very good choice because it's a hopeless exercise to do it without it being very boring or futile. So I think it's a very good choice. Yet there is one attempt, at least in relation to human rights, that is made here, I would like to pick. And that is the idea that in spite of Article 51.1 of the Charter, human rights or fundamental rights can be enforced through Article 2 as long as the essence of that fundamental right is concerned. So Article 2 would be a vehicle to enforce the essence of the fundamental rights of the Charter. And that is also a reference to an opinion of Advocate General Kokot, I think was the Stolichnaya case. And I have a bit of a problem with that logic. And I would suggest something that is inspired by the German Constitutional Court in that respect. What is that? I believe 51.1 of the Charter, which is a very problematic provision as it is, applies to the whole of the Charter, applies to all aspects of the fundamental rights enshrined in it, and doesn't make a distinction between essence and non-essence. So the essence idea comes up in 52.1 as one of the tests for the interference with the rights, besides the proportionality principle. But these tests come into play as long as the rights in the Charter are applicable at all. And if 51.1 precludes the application of the Charter, that precludes the application no matter what is involved, whether an interference with the essence is involved or whether the interference with the proportionality principle is involved. So it's a next step in the examination of a fundamental rights case. If you take a German doctrinal approach, first you establish that the right is applicable, and only then you think about whether that is justified and what way, how harsh the intervention was. Which is not to say that I disagree with the outcome, but I would suggest a different argument that is inspired by actually a judgment of the German Bundesverfassungsgericht against EU law, and that's the 2015 European arrest warrant judgment, where the court is circumventing the Solange II reservation through using human dignity, saying grave violations of the right to a fair trial amount to a violation of human dignity. And then the Solange II reservation and the limitation in it is no longer relevant. So you could go through human dignity to import the essence of the fundamental rights, because I think it's not very difficult to argue that the dignity content and the essence content of fundamental rights is basically the same. There is a lot about that in German constitutional scholarship, but at least you could import the most important aspects of all fundamental rights through the human dignity clause in Article 2, and then you don't have to go this difficult way around 51.1. Third, identity. I think it's a very, very wise and also diplomatic approach to try to make constitutional courts invested by importing constitutional issues that belong to constitutional identity into Article 2. I would call it appeasement even, and it's I think it's very wise, and I think for a concept like this proposed in this book, I think such moves are important. I only have one concern, and that is the dominance of the competence question in the identity case laws of constitutional courts, predominantly in the German Constitutional Court, where the democracy principle is used to prevent the transfer of certain rights to the Union. So at the end of the day, this lofty idea of democracy, which we all cherish and agree with, is just a tool to prevent certain competence transfers. Now, how would you include that into an EU constitutional identity, the very core democracy and competence arguments? And that leads to my fourth and final substantive remark, where I would be very much interested in more discussion by the author, or I missed the discussion, but I understand that it's you choosing the subject matters. But I think there's one thing that is very important and very timely, and that's the question of democracy as such, as one of the values. I understand you didn't want to discuss the content of the values, and I agree with that. And in that sense, you don't need to discuss the content of democracy as such, because you don't discuss the content of rule of law and human dignity and anything else. Yet, from two perspectives, I think democracy would have been interesting, also in view of Article 10 and the potentials in Article 10 that are not yet explored completely. One is the fact, and I'm sorry, I do not mean to be overly skeptical here, but there is at least a substantive discussion on the democratic deficit at European Union level. So if you want to elevate the values to the level of a super constitution, like an Ewigkeitsgarantie in the treaty, which could even stay in the way of treaty amendments, which I call really revolutionary. In order to do that, you really have to say that Article 2 is comparable to 79.3 of the Grundgesetz. But if you want to do that, you will be faced with the problem that you elevated the principle at EU level to this very high level, the principle of democracy, where there are, I think, arguably some issues that are not impossible to solve, but still there are these issues. The second, for a more extensive discussion of democracy, is the potential in democracy and Article 10. In importing more charter rights into direct application against member states. Rule of law has been instrumentalized through Article 19 to import Article 47 Charter, judicial independence, fair trial in general terms. Not more. If you use Article 10 and Article 2, democracy, as a tool to elevate the charter rights into direct application against member states, irrespective of 51.1, but it's far more you can actually utilize. Not just the right to vote and stand at elections, but also freedom of speech, freedom of assembly, freedom of association. It's a bunch of political rights that are directly relevant for democracy, which would import far more into the case law, as Article 19 is importing a judicial independence and fair trial. That being said, I thought it's an opportunity to discuss these issues, but I don't mean these remarks as implying that the book is not coherent or not convincing. And in conclusion, I would like to repeat my congratulations to Luke and my thanks for his writing this book. Thank you.
Thanks indeed, Pál. Thanks for your intervention. Now we have some time for raising questions and comments. Two of them are already available in the chat. One point was raised by Lena Kaiser. It's about the pending infringement procedure. The other one was raised by Cédric Génard. Any other questions? If so, please raise your hands. Sì, poi le leggo. So I will first read the questions in the chat. So Lena Kaiser says, what are your thoughts on the pending infringement procedure based on Article 2 TEU as a self-standing provision, and especially which impacts would the use of Article 2 TEU as a self-standing provision have on the concept of three levels concerning Article 2 TEU as a function for deconstitutionalization? Cédric Génard, in turn, asks whether the perception of Article 2 TEU as a constitutional core and even as a potential eternity clause doesn't grant excessive power to the EU and in particular to the European Court of Justice. The suggestion can, of course, be understood in light of the German experience with Article 79, paragraph 3 of the Basic Law, but poses risks in an EU context. The counter-majoritarian debate can normally be solved by saying that the Herren der Verträge can always change and clarify the treaties and have the final word. This would seemingly not longer be the case with Article 2 as a constitutional core or eternity clause, where the interpretation by the European Court of Justice of a rather vague notion like values would always prevail. And Cédric adds that his question ties into the comment by Anna Bobić as well on why the member states would even accept the approach via Article 2 TU if their critique on the basis of national identity derives from their own core constitutions. If there are no other questions, Steyert.
Thank you very much. I also found the discussion really highly interesting and highly thought-provoking. I definitely have to read the book now, which was really interesting to get the thoughts on this macro characterization of the European or EU legal order, more or less, let's say. My question related to the relationship specifically between Article 2 and the Charter as well, because as we've seen in the presentation, Article 2 gives us a list of the EU values, but then there's also the second sentence which talks about kind of this, about the different kind of values of however we want to characterize this. But then I was also thinking about the preamble to the Charter, which gives us a slightly different characterization of the values on which the EU is founded, which notably characterizes solidarity, which is found in the second sentence of Article 2, also as a value of the European Union, whereas, for instance, democracy and rule of law are characterized as principles over there. So I found this quite intriguing, and I wanted to hear how this also related to your classification between Article 2 as this macro constitutional norm and then the Charter being placed slightly under. Obviously, the preamble to the Charter has not had the same judicial mobilization, so maybe as Article 2. So maybe this is kind of a practical practical order that you that this kind of order and also normative order this ordering is supposed to represent. But yes, but then also solidarity, for instance, this one value is not characterized as a value in Article 2, but in the Charter's preamble is also quite important to the Charter structure itself. And so this also relates maybe back to the point, to the kind of the idea of enforcing the Charter rights, because then we also have this distinction between rights and principles in the Charters, which often enough is kind of linked back to the solidarity right and provisions of the Charter. So I kind of also was wondering on one hand how this different characterizations of values might relate back to this order of constitutional norms in the EU, and on the other hand also what this kind of different characterizations of values could also mean eventually for the Charter rights. Is it a way of overcoming also eventually the rights principles divide? And yes, thank you very much. But it was really interesting, and thanks a lot for the presentation.
Thank you, Mark. Now we have one question from Maria Bartel. If you want to read it, and after that, Laszlo Detre. So, Maria.
Hello, thank you very much for the presentation.
Aril, sorry.
And all the comments made also by Anna Bobić. I am studying national identity conflicts, and I wanted to ask if the tribunal, if in the action of the Court of Justice, you find a sort of integration by stealth, because the court has applied the retained powers formula in cases regarding national identity, marriage, filiation, nationality, as you have already said, and the organization of the judicial system, and the court elaborates on these obligations that it finds that are derived by the values and the rights of the EU citizenship, and they are applied over the areas that remain part of the member states' competence and on which the EU has no legislative competence as such, but this is a sort of, this manifests that the EU has a functional competence, that it is not only based on the strict distribution of competences. So I would like to ask if you see this as a sort of harmonization by stealth. Thank you very much.
Thank you, Maria. Laszlo Detre.
Yes, thank you very much. Thank you very much, Dimitri, for the presentation, and also for Professor Sonnevend and Anna Bobić for the comments. Actually, my question connects to Professor Sonnevend's remark considering the rule of law, and that is that if you think about the essentially negative characteristic of the rule of law sub-principles, would you say that they are applicable in exactly the same way concerning the EU dimension and also the Verbund dimension? Because the rule of law sub-principles that have been applied by the Court of Justice, they are basically the same as they are in any national jurisdiction. So they are abstract enough to be considered as law, but they are negative, so they would never indicate what to do. So in this way, I'm just wondering whether you agree that there cannot be really made distinction in this regard while you apply them in connection to the EU and in connection to the member states. Thanks.
Thanks. Anyone else? Otherwise, I will take advantage of my position. I have two very short questions. The first one has to do with what you think of the proposal to amend the treaties that were passed by the European Parliament last week or 2 weeks ago. So since the interinstitutional balance plays quite of a role in your analysis of the enforcement implementation of Article 2 values, what are your thoughts about these proposals? And my second point has to do with your distinction between a constitutional core and
Giacomo, could you say what kind of proposal do you mean 2 weeks ago?
The resolution that was approved by the European Parliament with some proposals to amend the treaties, including transferring competences from the European Council to the Court of Justice when it comes to declaring the existence of a major breach of Article 2 values. So the idea of judicializing further the enforcement of Article 2 values. And my second point has to do with the distinction between a core and the frame when analyzing Article 2, and more specifically the regulation of 2014 concerning European political parties and foundation, and the decision and possible subsequent review of the decision of the European Agency on Political Parties and Foundations regarding the compatibility of European political parties with Article 2 values. So same values as in the crisis in the member states, but a different field, a more, I would say, distinctively European field of relevance of these values. And in this respect, I'm curious about your thoughts, also in light of the distinction you make between a core and the frame function of Article 2 values. Thank you.
Well, thank you very much for all these questions. And first of all, thank you very much to Anna and Pál for these excellent comments. Indeed, a lot of food for thought, and it's a great present to me, actually, and a great service to engage with the book in that detail, and yeah, to come up exactly with the problematic issues. So maybe I start with the comments and then go to the questions. I concentrate on just a few. I mean, I'm in the comfortable position here to just pick and choose now, and to avoid the ones that make me feel uncomfortable. Well, I start with Anna's question: why did you not define the values, at least a little bit, or why did you not attempt to define them? And this also goes maybe to what Lena Kaiser asks in the chat. What about a self-standing application of Article 2? How could we do this? Actually, all this locks in together in this respect, in my view, because I intentionally did not go into the meaning of the values and the content, because I think that the Court of Justice should also not do this. What I advocate basically is a negative approach, especially when we are talking about the enforcement of EU values in the member states. The court should, as much as possible, refrain from giving Article 2 a meaning, a positive meaning. What it should do is sketch a red line in a case where that comes to the court, see whether this threshold is crossed in a specific case, and then not tell the member state what to do instead or how to positively remedy the violation. So only to find the violation in a negative sense. because that is then much, and I mean, you said it yourself, where is the place for pluralism otherwise? And I think that's the only way to preserve a meaningful space for constitutional pluralism in that sense, to take this negative approach as a as a leitmotif, so to say, for the court's enforcement of Article 2 in the member states. And that means then that you have to, if you cannot then establish a specific content, it's always on a case-by-case basis, and some, let's call them, the court needs to apply some second-order criteria, such as, for instance, the intention, the overall context, the gravity in specific cases of violations. Is it widespread? Is it persistent? What do other international and European institutions that are also tasked with, for instance, protecting fundamental rights say about this issue? Is there a lot of international criticism? And so on and so on. So it is a very, very complex assessment, I would say, to actually establish a violation, crossing this red line in this specific case, without fleshing out the content of a value. So that is how I would suggest the court should proceed. And we see that also in the application by the European Commission, and that then goes to Lena Kaiser's question, in the Hungarian LGBTIQ case. Because here, Article 2 is mentioned just in the end. And if you, well, I know that you don't have the application, maybe you at the court, I don't know, but I worked for the commission and I had a look into the application of the commission, and it is really a very, very short part only on Article 2 that says we are not fleshing out the content. It's really about gravity, it's about persistence, it's about intention, and all this coming together, together with serious fundamental rights violations that really go to the core of these fundamental rights. That means we are actually taking this one step further and elevating the echelon and go to Article 2. So that is then how the Commission actually conceives this self-standing Article 2 in that case. And I think it's a good approach to do it that way. It's a wise choice. And that ties actually in with a remark by Pál Sonnevend. Pál, you said that you don't think that the court should review systemic violations of Article 2. And because, I mean, courts are usually tasked to adjudicate specific cases. I would disagree with that. I mean, we have several instances where the Court of Justice is specifically also tasked to review systemic violations. Let's just think, I mean, there's many fields. I mean, let's talk about the European arrest warrant, the Aranyoshi case law. Let's talk about Dublin NS, where it's also about systemic violations. Let's talk about environmental protection, where we have the Irish waste cases, where it's also about systemic violations. We can talk about also in environmental protection about some of the Aarhus criteria. And the Janacek case, where it's about the quality of the air quality, also systemic violations. So there are many, many instances in which courts, European courts too, can actually adjudicate on systemic violations in a broader sense. It's not always about just one isolated incidence. So I would disagree that this is this would go beyond the mandate of a court. Coming back to a comment by Anna, or well, you voiced your critique that you are not convinced by using Article 2 instead of identity, and I completely see the point, because that's the reason why I include a whole section on that, because I got very much the same backlash at the Institute when I presented the chapter there at the Max Planck Institute. And you said, well, why should actually the courts do it? And is this not exactly the counterintuitive? I mean, identity is about selfhood. You know, national courts should decide on the identity, and so it is not about commonality. It's about distinction from something. I would answer to that this is only one meaning of identity. This is identity as ipse, as selfhood. But identity can also mean commonality. I mean, two things can be identical, and that expresses that they are the same, même in French. And there is actually a very good article, I think by one of your colleagues, Sterk, at the Court of Justice and the European Law Journal, expressing exactly these two facets of identity. And the second dimension is stressed by many constitutional courts, actually, when they extrapolate these fundamental principles being part of their identity. Just to name a few, the Czech Constitutional Court, for instance, said that there is an identity of values in the Lisbon case. The same was the Polish Constitutional Tribunal before its captures. In its Lisbon judgment, said that there is a full axiological compatibility. The same then with the Portuguese Constitutional Tribunal, which stated there is an equivalence of constitutional values, and the same Spanish Constitutional Tribunal, same thing. That these are basically the same principles, and I would agree with that. I mean, if you look actually into Article 20 of the German Constitution, you see that's the German identity together with Article 1. It's basically democracy, the rule of law, and fundamental rights in their essence. So these are there is an equivalence, at least on that principled level. So I would say it's not expressing these principles then is not only about declaring your own nature. It's really about the concern of these courts is more to protect some very fundamental principles, not to exert sovereignty or national identity in the sense, I would say. And I think they could do so much, much better over Article 2. It's much more effective. But of course, and this then comes back to Pál, the issue of competences that you raised is very difficult, or I would say impossible, to frame as an issue of Article 2. That is indeed a problem. And this is a huge bunch of the cases of the Federal Constitutional Court in Germany, which, well, then escapes this idea I have here. But the case you mentioned in 2015, for instance, where the court referred to human dignity, would have been a perfect case to apply this doctrine. They looked actually at the European arrest warrant, assessed it whether actually that complies with human dignity to surrender a certain person that was convicted in absentia by Italian courts, and found, yeah, well, it would violate human dignity, but the European arrest warrant actually does not require us to surrender that person in this case without referring to the Court of Justice. Here, the court would have been able to actually, or the German Constitutional Court would have been able to kind of apply this Article 2 idea I sketched in the book, in my view. This brings me to the next point. You are not convinced, Pál, that Article 51 could be circumvented, or that there is a problem with Article 51 if we're talking about how to actually protect the essence of EU fundamental rights in the member states beyond the scope of other EU law. And I mean, there are, I think, two ways how to deal with this question. And the one goes back to your colleague, Hungarian colleague András Jakab, who already in 2016, I think, he developed the idea that Article 2 could trigger the scope of the Charter. So he says, well, of course, we say the Charter has a derived scope of application. That's true. It's in Article 51. So we always need some kind of union law to trigger the Charter scope. But why couldn't Article 2, in these very grave and systemic situations, become applicable and then trigger the scope of the Charter? Because Article 2 applies in these cases. So that would be one idea. The other idea is to apply a teleological reduction, which is a then German hardcore legal doctrine, and to say, well, Article 51 as part of the Charter and primary law must be interpreted in light of Article 2, because that then derives from this material hierarchy I tried to develop in my book. And if there is this material hierarchy, then I think it's only logical to interpret also these limitations of the Charter in light of Article 2, and interpret Article 51 as in that sense that it cannot circumspect or not limit the effects of Article 2 in that sense. So if we have a violation or a breach at the member state level that reaches the systemic nature and persistence and the thresholds then of Article 2, then the Charter cannot, or Article 51 cannot limit that provision. So these could be two ways how to deal with that problem or obstacle. But I see that you're not convinced by that. And I can understand. I mean, it is a bold move. So we have several other questions now. To Cedric. Yes, I mean, of course, all this, everything I sketched in my book leads to more power for the court. I mean, that is clear. I mean, you asked the question, if I understand correctly, whether this perception of Article 2 as a constitutional core does not grant excessive power to the Court of Justice, and I mean, especially understanding it as an eternity clause. But you're right. Definitely. That is the reason why in 2 chapters I try to limit that or show where the court should employ all these doctrines I sketch with self-restraint, and how it could limit it. For instance, by applying a margin of appreciation doctrine and so on and so on. But I think one thing is very important to restate or to stress. Everything we talk about concerning Article 2 is an exceptional situation. So what the court does now with regard to the Polish judiciary, in my view, goes too far if we would see that as an application of Article 2. Because, I mean, here the court goes into very fine detail. It spells out criteria for judicial independence in so much detail that, in my view, this goes too far. So Article 2 is about exceptional situations. That applies also to treaty amendments. So we would talk about something that is not the union we are living in anymore. Something that is something completely new. And so if we keep that in mind, I think then this excessive power seems already very much reduced. This is about exceptional cases. So not about the everyday application of EU law. Very different, for instance, if we think about the doctrines of Van Gent and Loos and Costa Enel, which basically guide our daily application of EU law today. That is not what I'm describing here. Then yes, integration by stealth. Actually, I think, Maria, that ties into the question by Cedric. I mean, isn't that all just more harmonization? And again, I would say, yes, it is about harmonization, but at a very narrow basic level, especially once we are talking about the Verbund dimension. It's about establishing, and I mean, Anna said it as well, and wrote some excellent pieces about that. It's about preserving the basics for a pluralist system to be sustainable. And we need that. I mean, without that, the pluralist system collapses. I think there was a paper, yes. It's about the unspoken core of constitutional pluralism, only that this time I tried to make it, to tie it back to Article 2. So, In any case, I'm not sure whether actually I got all questions. Giacomo, yes, the proposal and about the justiciability of Article 2 in the context of Article 7 and tying in the court in that process. That goes actually back to a very, very old draft from the 80s, when this procedure, Article 7, was introduced for the first time in a draft from the European Parliament of the new treaties. Then it was in Article 40, and it was in the context of the Spanish, Portuguese, and Greek enlargement. I mean, we have to think that these were formerly fascist countries that then returned to the path of democracy and then joined the Union. And so there was already kind of this idea with the Spinelli draft to include a certain Article 7 procedure. And then in that Spinelli draft, it was the Court of Justice that should be, as a first step, establish whether there is a violation of Article 2. To be honest, I lost any hope that the Article 7 procedure, as it is today with anonymity, will ever work in practice. So whether you tie in the court or not, to me, that makes no difference at all. And I know that, Pál, I think you disagree in that regard, but I think that there is no use of that instrument in a union of 27 member states. It simply won't work to get anonymity on such a fundamental question. I think that procedure is largely useless. We don't need that, at least not in its current form. And the point is that it is very unrealistic that anything in that regard will change, because we won't get the Hungarian and the Polish, well, the Polish vote, let's see, after the elections, but the Hungarian vote, not. So I don't think that anything will change here. And with regards to the political parties, yes, actually, that is I mean, you said that one criterion for a political party to be allowed actually to stand for elections is its compliance with European values in Article 2. And I know that Article 2 is mentioned in that regulation, and that is actually a very fine example for the Constitutional Court. That's the European dimension of democracy. And I would say that the court, which is the only thing I'm looking here actually at the moment in the context of my book, would have a very strong role to play in assessing whether a political party actually complies with these values. So yes, that's definitely something that's a good example, which I didn't include in my book at that moment. But yeah, thank you very much for bringing this up. I hope I answered most of your questions. If not, please feel free to write me an email. I respond very quickly. So again, thank you very, very much. That was really a fantastic feedback and discussion. I mean, a lot of food for thought.
Thank you. Thank you. It has been a fine debate. I don't know if Anna and Pál have any other remarks. Otherwise, I would just like to thank you all. So the author, the two discussants, Giuseppe for, let's say, playing a key role behind the scenes, all the colleagues, all the friends in the audience. And so see you for the next STAUS webinar. And again, congratulations on this great monograph. Thank you.
Thank you, and well done.
Bye.